Tim McIndoe.
Kia ora, te mana whakawa, tēnā koutou e te whare. This is a fairly unusual experience in that this is the first time I can remember in my 7.5 years as a member of the House where the government, having opposed a measure at its first reading, is now supporting it at its second reading. And I want to traverse some of the arguments why that might have come to pass. So I think we need to reflect on some aspects of the history of the bill. One is that, as my good friends on the Government Administration Committee have said to me, there were only 5 submissions received on the bill, which would suggest to me that there's a very low level of public interest in this particular measure. Nevertheless, I don't want to be dismissive of that because of the 5 submissions that were received, all were in favour of the bill being passed, and 2 came from quite august bodies of which this House always takes note and listens to with respect, i.e. the Law Commission and the Law Society. And of course it's also notable that in their deliberation, or their report to the House following their careful consideration of those submissions, the Government Admin Committee has advised that they are in unanimous support that the bill should proceed. But so, taking that into account, I have to say I was very disappointed tonight that the member in charge of the bill gave us very little of his personal reasons for supporting it, and in particular, the purpose of the bill. In fact, I'm not sure that he actually mentioned anything about the purpose of the bill whatsoever. Essentially, what he confined himself to in his relatively brief speech were questions of process. I would have expected to hear some compelling arguments in favour of the bill from the member. And so for that reason, I want to put a few questions to him that he might give some thought to as he moves on to the next step, because, beg your pardon, it appears that the bill will pass tonight, and so as he prepares for the committee stages of the bill, I'd like him to give some thought to a few questions. But nevertheless, I do congratulate him, as others have done, on having had his bill adopted, if not unanimously. Looked for a while as if it might have been unanimous, but of course the New Zealand First Party hate to be agreeable, so it now looks as if it will just be adopted comprehensively, and that is a very rare thing for any member putting forward a member's bill, and particularly an opposition member. So I do congratulate Mr Ruruwhe for that particular fact. Of course, the only current Parliamentary Under-Secretary is Mr Seymour, and he gave his warm endorsement to the measure before effectively describing it as, I think, completely pointless was his description. So I felt, well, in an effort to educate myself as to the purpose of the bill, because I hadn't had much of that from the member in charge of it, and I wasn't sure after listening to Mr Seymour that I was much better educated, I decided to try to bring an independent analysis to Mr Seymour's less than generous assessment of the bill by turning to what you might know of as the Parliamentary Bible, otherwise known as David Magee's Parliamentary Practice in New Zealand. And it's always a wise place to start if one wants to understand a little bit more about parliamentary procedure and constitutional provisions. But I have to say, sir, that despite the impressively comprehensive and scholarly tome that Magee's text undoubtedly is, references to parliamentary under-secretaries in Magee are relatively few and far between. He notes that a parliamentary under-secretary may answer questions on behalf of a minister in the minister's absence. Otherwise, a parliamentary under-secretary cannot perform functions conferred by the standing orders on a minister, such as taking charge of a government bill. On page, they're coming, Mr Farfoy, thank you so much, it's lovely to know that you're listening. On page 331 of the 3rd edition, Magee notes of private members' bills, and I'd just like to read from this particular passage, that a parliamentary under-secretary may introduce a member's bill. So that led me to think, well, in that capacity, will an under-secretary now face scrutiny which other members who are introducing a bill will not? And that is a matter that I would commend the member sponsoring the bill to give some thought to as he approaches the committee stages. Later, Magee, on page 533, noted that a minister or a parliamentary under-secretary to the minister whose measure is under discussion, who quotes from a document relating to public affairs, must table that document if requested to do so by any member. So, of course, there's a few degrees of accountability in that. But at page 558, and Mr Speaker, if you just allow me to read a slightly longer passage from Magee, he notes and I might need to put my glasses on. He notes that a question cannot be addressed to a parliamentary Under-Secretary in his or her own right as if the Under-Secretary were a minister. Questions to ministers must be addressed to ministers of the Crown, including now an Associate Minister. A parliamentary Under-Secretary may answer a question on behalf of a minister, but can have a question addressed to himself or herself personally as a non-minister only in respect of parliamentary proceedings of which the Under-Secretary has charge, for example, as the chairperson of a select committee, not in respect of the wider range of responsibilities for which ministers are answerable. Thus, a question to a parliamentary Under-Secretary relating to a statement the Under-Secretary had made was not allowed in 1977, even though the statement was made in respect of the Parliamentary Under-Secretary's official departmental duties. So, sir, there is clearly an essential difference between the two roles, and I ask the sponsor of the bill moving right along, Mr. Robertson, thank you, sir. I asked the sponsor of this measure, as he prepares again for the committee stages of the bill, whether the official information Parliamentary Under-Secretary's amendment bill, which we're considering tonight in his name, will have the effect of changing that constitutional distinction and perhaps force David McGee out of his well-earned retirement in order to update or indeed write a fresh edition of his parliamentary masterpiece. So, as Ruth Dyson, the chairperson of the Government Administration Committee, argued, this bill should not be about David Seymour, and Ms Dyson told us that it clearly is not. But I have to say, although the member for Epsom seems to delight in the thought that it might be, and the Select Committee's report to the House after their consideration of the bill, while little more than a page in length, is nevertheless about 3 times the length of the bill itself, one cannot escape the conclusion, as my good friend, the learned and distinguished member for Rodney noted earlier, that this really would appear to be the pick on David Seymour bill. And given its incredible brevity, one would also have to wonder whether it isn't a case of much ado about nothing. But I listened to the contribution of previous speakers with interest, and I thank them, particularly those MPs and the members of the committee and their officials, and those who submitted on the bill for their careful consideration of it. All speakers, sir, have noted that transparency and accountability are important features of good government. There is no argument about that, of course. If this bill will enhance that outcome, then it's perhaps a good thing. And we can support it, and indeed the National Party has decided tonight that we will support it at its second reading. But I join Mr Mitchell in questioning the sponsor's real motives for introducing it. Is it really just an attack on David Seymour? Because, as Ms Dyson is interjecting so effusively at the moment, she might want to reflect on the contribution of her colleague, the member for Rimutaka. Because in his diatribe about partnership schools, and of course we hear that quite frequently from Mr Hipkins whenever he is speaking in the House, you would have to say that he lent credibility to the view that this is the pick on David Seymour bill. And really, given that that came from my opposite number in the whip's desk across the House, I'm left thinking, well, that probably is the real motive. But I don't want to attack Mr Seymour, Mr Hipkins, rather. It'd be churlish to do so, because I'd like to congratulate him on the double dose of happy tidings that we've heard recently. I gather there's both an engagement plus a baby to come, and that's wonderful news, and I do feel that all members of the House would want to celebrate that with him. So let me end as I started. Initially, the National Party didn't support this bill because we believed, and we still believe, that there are strong mechanisms to keep government to account without having to go down this particular path. Although parliamentary Under-Secretaries are not members of the Executive Council, they do perform an important constitutional role with powers and responsibilities delegated from the responsible minister. Any official information relating to their work as parliamentary Under-Secretary, can be sought from the minister to whom they are responsible. So this bill may help to ensure transparency across government. It's clear that the public wants that accountability, and no one wants to hold that back, particularly from those who perform public functions. So, as a government that has always championed accountability and transparency in government, we've taken steps over the last 8 years to try to ensure that ministers and government agencies are accountable to the public. So, while I'm not entirely convinced that this is going to be a vital constitutional innovation, along with my colleagues, sir, particularly as you're giving me the message that I should conclude these remarks, we will support this at the second reading.
The question is that the motion be agreed to. Those of that opinion will say aye. Contrary, no. The ayes have it. A party vote is called for. The clerk will conduct